mother of LG children.
Yes, good morning, Ms. Batchy.
Good morning, my lords. As you know, I appear on behalf of the appellant mother. I'm very grateful that your lordships gave her leave to attend remotely today, and I understand that she's going to be signing in on the live link.
Good.
Next to me is Miss Baker, who represents the local authority, along with her junior Miss Stapleton.
Yes.
It's Miss Stapleton who attended the final hearing.
Yes.
We then have Mr. Braithwaite, who represents the father of the eldest child.
Thank you.
The father of the youngest child is not in attendance today, Mr. Story and Miss Slee, who
Yes.
represented him within the final
Perfectly
hearing.
understandable.
Had no funding, I'm afraid.
Well, also they didn't file anything, did they? So we haven't got any documents from them either, have we?
Well, only because they didn't have any funding. My understanding is that they support my position.
Right. Well, I don't think that's going to make much difference.
No.
So,
No. My lord,
yeah.
the bundle has been sent to the father of the youngest child. He's been sent the link to be able to log on today. We've not had any other communication with him. And we then have Miss Hooder at the end, who represents the Guardian. The Guardian is not in attendance today.
Well, could I just apologise to you all for you having been kept waiting? We were having an important discussion about the case, and that's why you have been kept waiting. But I imagine we have ample time to do justice to the appeal. Can we think about identification of the family? The normal direction will apply, namely that no report of this appeal is to identify the children or their family members. It will be a discipline which we'll do our best to observe, not to identify them by name. Clearly, when we're talking about the father in this case, we're talking about Mr. Braithwaite's client, the father of the older child. We can, I think, refer to Mr. G, because there's no way on earth that we're not going to be able to do it differently. The title of the case is LG, and if we can get by in referring to the older and the younger child, that'd be helpful. Experience shows that if you ever come to be reading out anything that's written on paper, that's where it all goes wrong. Provided everybody does their best, it's not a disaster. If it's important, the tape can be edited. But let's try as much as possible. Before you start, could I just check something in case it's, as I'm sure it will be in trial counsel's knowledge, to understand something of the geography, because again, I don't want to identify where the family lives, but can I put some propositions to you which you can correct?
Yes.
If it's not right. We're concerned here with a mother, a father, Mr. G, and a grandfather, amongst others. My understanding from reading the papers is that the mother and her own father, the maternal grandfather, live in close proximity to each other, or not too far away. Is that correct?
That is correct.
And that's in Town 1. And that Mr. G is also a resident, insofar as he's resident of Town 1. That's where his connections are.
Yes.
And in particular, his own mother, who has played an important part, I think, apart from anything else, as a contact supervisor until before the judge's order, is also in Town 1.
She also remains a contact supervisor.
Okay. In contrast, Mr. Braithwaite's client is in Town 2.
Yes.
With his partner and their children.
Yes.
And that Town 2 and Town 1 are about 10 miles apart?
My lord, I'm not sure of the exact distance, but it's about a 40-minute bus ride was my recollection
it's
from
about
me.
25 minutes in a
Yes.
car, according
Yes.
to the usual if I have the right towns, we're talking about that sort of geography.
Yes.
The details don't matter at all, but those are the geographical settings that we have here. Now, could you also, for our information, update us on what has taken place since the judge's order of the 29th of November? Up to that point, the children were living with their mother, and the older child was attending school.
Yes.
In Town 1.
Yes.
What happened after the judge's order?
After the judge's order, I understand that the eldest child went to stay with her father. I think, firstly, on the premise of contact, but in fact remained residing there with her father, and is now in school in Town 2.
Right, so we're now in the 23rd of January, so in practice she's been for about a fortnight
Yes.
at school in...
I'm not aware if she started just before Christmas or whether it was after. I don't know whether Mr. Braithwaite can help us with that, but she's certainly at school in Town 2.
Right. And reverse contact has been taking place.
Yes, and in fact, the mother is having additional contact at Mr. Braithwaite's client home, his home. My current instructions, and I was trying to canvass this morning whether anyone else was aware of this, is that the stepmother,
yes,
in Town 2 has asked my client to attend their family home in the evenings to assist with bedtime routines.
Well,
Because there are
at all events, I don't want to stray too much into sort of qualitative detail, but one way or another, the judge's order has, as it were, been put into effect, and that the adults involved are making it work as best it can,
Yes.
mindful that there's an appeal now being heard.
Yes.
Right, and that the younger child has gone to grandfather.
Maternal grandfather.
Are you able to be a little more specific about what the actual distance within Town 1 is between the mother and the grandfather?
Well, I'm just trying to recall the grandfather's evidence, because he gave quite clear evidence as to what he was able to offer. And it was and I'm sure I'll be corrected if I'm wrong, it was a short car ride.
Okay, within the what is not a very large town.
Yes.
All right. Okay. Well, thank you very much for that context. And you now have understood that we are very much aware of the factual background, which includes the background of the proceedings relating to Mr. G's previous family proceedings.
Yes.
And have access to the judgment that this same judge gave in those proceedings. So you're of course welcome to draw out any aspects of the factual context, but I don't want to draw you into giving out details that you prefer remain confidential. Are there any matters in relation to the factual background that you'd like to take us to before we hear your argument about what has
No, my lord, not in terms of the factual background, although some of my expansion on my arguments relates to the evidence that the grandfather gave in terms of what he was able to offer. And that's dealt with in my written submissions that were provided to Her Honour.
To conclude, I hope my question about this, the sequence of events, just to have it absolutely clear, is that the judge and the parties, no doubt, were all under a lot of pressure as this hearing came to an end. So could you just talk us through what happened from the moment when the last witness, as it were, concluded their evidence, how the process by which the decision was delivered?
Yes. My lord, we provided written submissions. I think it was overnight or a day later. I have to say, I can't recall exactly. Was it? We had the weekend.
You had the weekend.
Yes, we had the weekend. We provided written submissions all at the same time.
And it had by then overrun its timetable. had it?
Yes.
Yes.
Yes, and the judge had made clear that she was going straight into another, I think, 10-day final hearing.
Yes.
She then listed the matter for a remote hearing in order to give judgment the following Friday.
Right. Can we just pinpoint that the
What I had in my first. Now just those dates I
right,
had.
the 29th of November, which is the date of her judgment, is a Friday indeed.
Yes, so that's when she gave oral judgment.
Right. So what we have is you were in court in the week of the 18th of November. You delivered your submissions on Monday the 25th or thereabouts, and the judge then gave a shorter oral judgment on the 29th,
Yes.
and her written judgment in I think in first instance on the 2nd of December, and then there were some questions asked about it.
So the first version of the written judgment was provided on the 14:21 on the 1st of December, which is the Sunday.
Right.
So just after the Friday that we have the oral judgment, with a request for clarifications. The local authority then sent the email that's referred to in my skeleton argument at page 22, which set out the clarifications from the local authority and from Mr. Braithwaite. The Guardians followed a little bit later. I had in fact asked for the stay on the 3rd of December, on the Friday, straight after the judge had given her oral evidence, which was refused. We then made our application to this court on the 2nd of December.
So on Friday the 20th hearing week commencing. So your application for a stay was made at the conclusion of the oral judgment.
Yes. And for permission to appeal as well at the same
Yes.
time.
And was that hearing face to face or was it remote?
It was remote.
And it is a puzzle, at least to me, as to what happened to your application to a stay.
It was refused.
Why?
Her Honour didn't feel that it was an application that she should grant.
Well,
Having refused
I
me-
just want to understand. I mean, there's clear authority about this, which no doubt you're aware of, and the judge would be. Was the judge referred to that?
She wasn't.
And equally, that was presumably on a Friday morning, was it?
It was Friday afternoon.
Friday afternoon.
I think it was 3 o'clock was the hearing was listed.
It was open to you to make an application to this court, but in fact, the application was made. You told us on
On the Monday.
the 2nd. Did you say?
Yes.
Is that in the papers?
It is. It's in my skeleton argument at page 23. At paragraph 19.
Right, and the actual, the 4th of December, the actual appellant's notice was filed, and you say that was preceded. Give me the reference again to your skeleton argument.
It's page 23, paragraph 19. My instructing solicitor made the application for the stay on the Monday, the 2nd. I had then
An application to whom?
to this court, to the Court of Appeal.
When? I mean, presumably was that just simply by an email, or I mean, I've bound to say I have no record of an application of that kind being made, because if those applications are made, they're referred immediately to a judge for a ruling.
My lord, I haven't seen that documentation. What I know is that I was sent an email from my instructing solicitor. I had, having thought about what areas that we might want to be considering for an appeal, had sent her a list of thoughts to her. She then contacted me to say, by email, to say that this court had asked for grounds to consider the stay application, and she had forwarded that document, which was not a formal grounds document, to the relevant court, to the office. We were then asked for formal grounds and a skeleton.
The appellant's notice, which we've got in the bundle, which is dated the 4th of December, says that it attaches as grounds for a stay. So actually, it seems to be dated. It's dated the 2nd of December at the back, and then sealed on the
Submitted and sealed.
Submitted on the 4th and sealed on the 4th. But at the end of it, it's dated the 2nd, and it does say in support of the application for stay that there's a separate sheet attached, but not in my bundle. There was a separate sheet attached. Would those be the grounds that would have been sent? You were saying that there was a document sent setting out the grounds for a stay. It appears that something was intended to at least be attached to the appellant's notice.
My lords, I wasn't involved in terms of the documentation that was sent in relation to this application. I was informed that my document, which has just had a list of thoughts about grounds, had been sent to this court because we had been asked.
Yeah, I was just trying to help by trying to identify if somebody's got a better copy of this.
I don't think we have. My instructing solicitor is the person who's going to be able to assist us with this.
All right. Well, can we put that to one side for a moment, and in due course, could you just gather together the information, share it with your colleagues, and just let us know, because clearly this has got nothing whatever to do with the merits of the appeal, but I'm obviously concerned if an application was made that didn't come to judicial attention, because I mean I granted permission to appeal on the 19th of December, and I'm fairly sure that will have been in a very short time after I first became aware of the case. So let's try and complete the picture.
Yes.
But at all events, we can take it that, in a sense, the substance of the judge's decision was put into place pretty much straight away after the refusal of a stay on the Friday, the 29th.
Yes. I know that we had asked the local authority if they would hold off actioning the removal of the children from the mother until we had made the application for the stay.
Do you have a date for when the children were removed from?
Your Honour, I don't.
Right, find out, please.
My lord, I'll make that inquiry.
Once again, that's been helpful. Thank you. So over to you, if I may.
My lords, you have my reduced ground, and I'm very grateful for the indication within the permission as to what it was that this court was concerned about in terms of giving us permission to appeal. Can I just say that I having read Ms Hooder's skeleton argument, going back to my grounds, I realised I'm not sure how, when we look at ground 2, I'm not sure where point D has crept in. I certainly rely on A, B, C, D, and then, sorry, D I'm not sure where that's come from.
So are you looking at page?
I'm
it's
looking at
our
page 18 of the bundle,
Yes.
which is in relation to my grounds. I think I've got myself mixed up with the looking at the mitigation of the risk of harm, and then going on to consider the comparative analysis of the advantages and disadvantages of the options available
But
to the
we
court.
need. Don't worry about the precise
I'm grateful.
drafting.
I'm grateful.
Speaking for myself, it seems to me that the main ground is indeed ground 2,
Yes.
and that what is an issue here is whether the judge's risk analysis is sustainable, and whether or not it's sustainable, whether she adequately balanced the advantages and disadvantages, because risk is not the only factor in determining welfare.
Well, my lord, that's where I was going to start, in fact, because I say that having gone back and looked at the judgment in much more detail in order to prepare for this hearing, what's really clear to me is that, in fact, ground 1 flows if you are with me on ground 2.
I couldn't really see what. I appreciate that there was a complicated history, which was no fault of anybody's because of pressure of time, but I wasn't really quite sure what ground 1 added.
Yes.
So does it add anything, or can we, as it were, lay it aside?
I think we can lay it aside because, in fact, I would say that ground 2 encompasses, if your lordships are with me in relation to ground 2, then it encompasses ground 1 in any event. Because really the crux of this appeal is that this judge failed to consider at all any mitigation in relation to the risk that she had identified from Mr. G, and fails to consider that when considering the options for these children. I want to deal first of all, my lords, with what the judge herself refers to as this being a very finely balanced case. She refers to that at paragraph 89 on page 89. And in fact also refers specifically to the evidence of the independent social worker, the guardian and the social worker, all themselves accepting that this was a very finely balanced case. And so it's all the more surprising that when Her Honour, after identifying the risk and the likelihood of risk, fails to consider any of the mitigation that was put before her in terms of reducing or alleviating that risk. Her Honour deals with the options for these children at paragraphs 80 and 81 of the judgment, which is page 88 of the bundle. First of all, I just want to point out that I say that there's a fundamental error in her consideration of the options, because when she considers 3 options for the eldest child in this paragraph, paragraph 81, she fails to mention her brother. So when she refers to, when Her Honour refers to the first option of the eldest child remaining with her mother, there is no mention of the fact that that would be remaining with her mother and her sibling, who she has lived with for all of his life.
She was clearly aware that was a consequence of her decision, was that the children would be split.
She was, my lord, but the whole crux of the mother's case was that there shouldn't be any separation, that these are children who had lived together the whole of their lives and were clearly thriving in their mother's care. And so actually just to consider placement with the mother without any indication that that's with the with her brother as well, I would say was just really encompasses the judge's approach all the way through. That this was really just about the mother for the judge and whether or not the mother would get back with Mr. G. And so when the judge comes to then, well, when she doesn't then come to look at the risk factors and how they can be mitigated or alleviated, she, of course, doesn't have in her mind how that impacts on this mother or the eldest child remaining with her mother, with her brother as well. And that's why I say it's important, the judge.
At the end of paragraph 81, I'm not going to read it out, but it's to do with continuous issues about continuing contact.
Yes.
This is your ground 3 point, is it?
It's part of my ground 3 point, because I don't know where the judge has got that from. I don't know what evidence she's relying on in relation to that point. What we do know is that the mother was allowed to have supervised contact with both children, supervised by grandmother, who was authorised by the local authority to supervise that contact. And so
about Mr. G having that
yes.
contact. Yes.
So I don't know where the judge has got that from, and I don't know what evidence she is relying on or referring to.
There was evidence about kissing and cuddling, wasn't there? But your point about under ground 3, which it seems to me is a subsidiary ground, but nevertheless one that stands on its own, is that the judge was really required to say what her findings were as to
yes.
whether the mother had complied with the expectations of her.
Yes.
Could we, while thinking about that, identify the sequence of events? The application for the care order was made on the 3rd of November 2023.
Yes.
And can you remind us of what, as it were, the protective measures were that existed between then and the judgment a year later?
There were interim supervision orders for both children. The mother had given an undertaking not to allow any unsupervised contact, and the paternal grandmother, so mother of Mr. G, had been assessed by the local authority as the person to supervise that contact. So those were the protective measures in place.
And so as I understand your argument, just expressing your argument, not expressing a view on it, but it was a core task for the judge to reach a conclusion as to whether those protective measures had been effective or not.
Yes. Well, Lord, especially when the Guardian, in her final analysis, was clear that that was a really significant issue for her, and that if, in fact, the mother had not breached that undertaking, then, on balance, favour must fall in the children remaining with the mother. Now, I appreciate that, of course, the Guardian then heard the mother's evidence
yes.
and took a different view. But I say...
Different point.
Yes, but I say that's it was entirely necessary for this judge. And I had referred her in my written submissions in some detail to the evidence in relation to the kissing and the cuddling and the events as to how that had happened, because my submissions to her and the evidence, we say, was that the father of the eldest child, who had a positive parenting assessment, who knew that this was a mother who had only recently separated from Mr. G, and therefore he was being supported by the professionals in terms of his child coming to live with him. We then end up in a series of events just before the final hearing where the child is not taken back to her mother as she should have been by agreement. And allegations then come out in terms of this child saying that she had seen the mother kissing and cuddling with Mr. G at contact. And so I had referred in some detail, Her Honour, in my submissions to the matters in relation to that, the evidence in relation to that, and what I say, or what we said in terms of the mother's case, that this was something she had to look at very carefully in order to be able to then assess whether this mother was going to be able to be protective going forward. And that then goes alongside the other factors that the Guardian had identified in her final analysis, and which the local authority had identified in their alternative care plan.
These are set out in your
Yes.
skeleton argument, which are lists of things that would be done if the children were with their mother.
Yes, and what the judge fails to do is consider any of that. So when we look at, if I just go back to the kissing and cuddling point, what we can see from the judgment is that the judge spends quite a significant amount of time considering the factual dispute about whether there was a separation between Mr. Braithwaite's client and his partner, and therefore whether that placement was stable. But gives hardly any time. In fact, I think it's a line where she refers to there being confusion about whether or not the eldest child was right about seeing the kissing and cuddling post-separation, and then doesn't go on to deal with it as a factual dispute and one that is highly relevant to the issues that she had to determine.
I'm just looking to see the place where you've included in these safeguards, paragraphs 49 and 50 of your skeleton argument at page 31. Was that what you were referring to?
Yes. So the local authority provided in bullet point form an alternative care plan which had been asked for if the children were to remain with the mother. The Guardian, in her final analysis, had already set out what I say is the comprehensive list of requirements if the children were to remain at home. In addition to that, she also had the evidence of the maternal grandfather, which again is only referred to very briefly in Her Honour's judgment in terms of him being able to offer some support, going around 2 to 3 days a week if that was what was required. But in fact, his evidence was much more detailed than that. And that's outlined in my written submissions to Her Honour, in terms of him being able to provide wraparound care for this mother, being able to provide assistance in terms of helping her break emotionally from Mr. G and remain physically separated. And the judge just simply doesn't deal with any of those issues.
These are in your final submissions, page 590.
Yes. Paragraph, I think it's yes, my Lord, when we look at page 88 of Her Honour's judgment, paragraph 82, we see her reference to the mother's plan that father stays with her 2 or 3 times a week. In fact, the mother's case was that she would do whatever it took, and if that meant that either she had to go and live with the grandfather or he would come to live with her, that's what she would do. So it was much more detailed than just simply a plan of him coming over 2 to 3 times a week. The judge also, towards the there is another reference to Her Honour referring to the grandfather's evidence when she refers to paragraph 79, page 87. In respect of the grandfather's evidence, he was a straightforward witness. He did offer to stay at the mother's home under a safety plan put forward effectively by the mother for 2 to 3 days a week. Well, that's wrong. But again, I make the point that the mother was saying, and the grandfather himself was offering to provide whatever was required in order for these children to remain at home. There's simply no mention of it within the judgment.
You referred to the grandfather's evidence about this. Was that reflected in your closing submissions?
It was, my Lord, and I'll take you to the...
Sadly.
So, my Lord, if we start at page 590, towards the bottom of the page is the heading, remaining with the mother with the safety plan in place. And first of all, refer Her Honour to the alternative care plan from the local authority, the comprehensive list from the Guardian, and then go on it's further down, my lord. 597, paragraph 36. I deal with the maternal grandmother as a separate point.
Hold on. So, paragraph 36 to 38.
Yes. And really, Your Honour, my lords, I was making a submission to this judge that this was a much more nuanced positioning for this mother. She had physically separated. The judge was right to be concerned. It was a very recent separation. The judge was concerned that there had been no emotional separation. But that doesn't mean it wasn't going to occur. The mother gave evidence that, in fact, she had separated from Mr. Braithwaite's client. He had separated from her. It was him that broke the relationship, and she had had to deal with that, despite it not being her wish, and she did deal with it. We know that the children did very well, and that she was able to co-parent really effectively with Mr. Braithwaite's client. And if she had to separate herself completely from Mr. G, she would do it again for the benefit of her children. And this grandfather understood that there was, it wasn't just about making sure she didn't come into contact with him, but also that she needed emotional support from him and the rest of the family in order to maintain that separation. It was much more than just him popping in and out. What's really difficult to then understand, my lord, is having failed to consider any of those issues, the judge then goes on to make an order which requires the children to be removed from their mother's care, separated from each other. The elder child, it appears from Her Honour's judgment towards the end, is going to be having significant amounts of time with her mother. The judge is quite clear that it's effectively a shared care arrangement, but for the elder child to remain with her father during the weekdays, in order to be able to go to school.
I was contemplating this, and I think there are 39 school weeks in the year, once one takes account of the holidays and the half-term holidays. And what the judge has ordered, as I understand it, is that the older child will spend 3 nights every second week with the grandfather / mother.
Well,
We'll come to that in a moment, but away from her father. So if we have 39 weeks of the year, then something like 19 occasions of Friday night, Saturday night, Sunday night, taking to and from school. And so by those means, by my maths, you get something like 57 nights of the year. And then for the 13 weeks of the school holidays, let's suppose she had 60% of that. And I'm not going to embarrass myself by doing the maths in my head, but I think you can all find that it comes something like 110 to 115 nights of the year. The judge's order provides for the children to be, let's say, available to your client.
Yes, yes. It's a significant amount of time.
And you know, we can work it out, but it's basically a third of the children's overnight time and a higher percentage of their actual waking time, because they're at school for so much of it. But
Yes.
you know, probably getting on for half of the children's waking time is to be spent with their mother. That's, I'm talking about the older child here.
Yes.
And that's under an order which contains no provision for supervision.
Precisely the point. Yes.
At the moment, it's a very unusual order that you've got here, because it has a recommendation on behalf of the local authority which is of no interest legally, that contact should be basically organised by the grandfather on terms laid down by him. Isn't that how it works?
Well, my lord, I say it's not quite as clear as that, because
Look at the order itself. Is it in the final order or is it in the special? It's not in the special guardianship order. Is it? It's in
the order of the.
I'm looking at the moment at page 66.
Yes, and of course those are recitals and not orders.
Let's just see what is said about the
So
younger child. Is it paragraphs
8
9?
B in relation to the if we look first of all at 8B in relation to the older child, regular overnight contact at the grandfather's home, including on weekends when the elder child is in the mother's care, with the court indicating that the contact could take place at either home. And then paragraph 9 is the local authority recommendation that the home takes place either at grandfather's or supervised by the maternal grandmother or another family member. There is no restriction on this mother. This judge, when we read this judgment, was so concerned about this mother coming back into contact with Mr. G and resuming a relationship, and yet there are no restrictions on her contact. Of course, it would be left to the grandfather as a special guardian in relation to the younger child, but when the older child is with this mother, there are no restrictions.
There's no supervision order.
No.
So in circumstances where the local authority is not at least holding a supervision order, a recital that the local authority has made a recommendation is not really of legal effect.
It's also not of effect when the grandfather, the preference of Her Honour in her judgment is for the grandfather to be present when Louis has this contact with his mother. There again is no order or restriction in relation to that.
Well, the actual contact order is at page 67, paragraph 4. Which is a perfectly standard,
Yes.
Unconditional order, but made against the background of recitals which appear between 8B and 10.
Yes.
And you're trying to encapsulate your submission is really that this is incongruent with the risk that the judge found justified the breaking up of the arrangement in the first place.
Well, it's difficult for the lawyers to understand. It's even more difficult for the lay parties to understand that on the one hand, this judge is saying that there is such a high risk and that this is a mother who cannot, under any circumstances, alleviate that risk, that this order is then in place.
The other side of this, as it seemed to me, is that let's suppose the judge had in fact intended, it's not what she did, but let's suppose she had intended to say that the risk is of a level whereby the mother must be herself supervised to make sure that she doesn't let Mr. G in, whether to live with her or to holidays together or to just accost her in the public places. But if she was to say that the mother cannot be alone with the children, it's not apparent that that's what her plan for the children is, but that would be an extremely difficult plan for the children's future, because it's not a normal way of an otherwise competent parent having to organise their lives, because you can't always require people to always be with you.
It also goes against the evidence that Her Honour was referred to in terms of the mother not having breached the undertaking during the course of the proceedings. The children had been in her sole care. The protective measures in place were limited in terms of the interim supervision order, the undertaking and the supervision of contact. And the mother had abided by those. There is no evidence that she had breached that. And that's why I say it was even more fundamental that Her Honour failed to deal with the factual dispute in relation to the kissing and the cuddling. Because if she had found against my client, then that of course would have fed into the concerns that Her Honour had, and I would have to accept that.
There's a difference between your client is lacking insight and weak because of her feelings, and a finding that your client can't be trusted.
Yes. My lord, precisely. And that's why ground 3 follows, because that is part of Her Honour's analysis in relation to my client. And so there are 2 points. There's the point in relation to the points I made earlier about Her Honour referring to bear with me, whether or not there were issues about the elder child having continuing to have contact with Mr. G when she shouldn't have, and the judge makes reference to that at paragraph 81, page 88, without any reference to any evidence, or there were no submissions made on that because it wasn't a matter.
That's the last line of that paragraph. We looked at that earlier.
Yes, it's the one we looked at earlier. But more importantly is the paragraph that I refer to, where the judge refers to evidence that she says she's aware of, that none of us were aware of, and which in fact her legal team say is absolutely false. My instructing solicitor was my junior for that case, and provision was made for the mother to remain either with my instructing solicitor outside of court, or on the last 2 days with the maternal grandfather who attended. There was one occasion when Mr. Story of King's Counsel required a room in order to be able to take some sensitive instructions from his client, and we gave up our room, and the mother sat outside with the paternal grandmother, so mother of Mr. G, while we were around. So where that evidence came from, that the judge seems to rely on in terms of them having spent time outside of court together and in a room, I'm afraid I don't know where that comes from. It was never raised either in open court or before or after submissions, or before Her Honour gave her oral judgment on the 29th of December. And in fact, it wasn't contained within her oral judgment, it was within the written judgment that we got 2 days later, 3 days later on the Sunday.
And in the particular circumstance of the case, the fact that your client may have been sitting outside with Mr. G's mother was not a cause for concern, in that Mr. G's mother was, in fact, the contact supervisor,
Yes.
With whom the mother had a good relationship, and so it wasn't one of those cases where any contact between the maternal and paternal families was suspect.
Except that Her Honour was concerned about it. That the maternal grandmother, having been authorised by the local authority to supervise that contact throughout the duration of the proceedings, there appeared to be no difficulty with the mother going along to that contact, but Her Honour clearly had an issue with it. And I say that that's referenced within that.
Well, she treated the fact that the mother got on perfectly well with Mr. G's mother as being a risk factor for the mother resuming or continuing a relationship with Mr. G. But that's a separate point which doesn't seem to feed into the arrangements at court being objectionable.
Except for Her Honour, it was another example of this mother not being able to separate from Mr. G. That's the point, because when we and I want to just look at this paragraph in a little bit more detail. So it's page 86, paragraph 75, and halfway down, when Her Honour refers to the example of, although the mother sat, in fact, if we just go up a few points, from what I saw of both giving evidence, I'm not satisfied that they have effectively emotionally separated. And Her Honour really sets out her concern. I think if social services were not involved, they would resume their relationship. That's what Her Honour is really concerned about going forward. As an example, and this is the point, that she relies on this evidence to feed into that concern and to confirm that concern for her.
Yes, we see what's written there.
But when we go over the page, the judge immediately then goes on to, whilst I accept that the elder child may be confused about what she saw when she saw them kissing and cuddling, the way their body language was towards each other, it could have been perfectly possible. That is another line where I don't know what Her Honour is referring to in terms of the body language. Is it body language that she is referring to that she has seen at court, or whether it's at contact? There was no evidence given in relation to the way that the body language at court. The maternal grandmother wasn't asked to give evidence.
What's the status of that sentence in terms of a finding of fact? What's it about? One thing's possible and another thing is also possible.
Yes, it's not a clear finding. So I think just to summarise, my lords, the difficulty that we've had in trying to explain this judgment to my client, it is, yes, there is a risk from Mr. G. The judge has assessed that risk as a high likelihood. The judge has then gone on to make orders that separate your children from your care, but from each other as well. But what I can't tell you is what the judge thought of the position that you put forward, in which you say that those risks and the likelihood of that risk could be alleviated. There is simply no mention of it in any of the detail that Her Honour was referred to, either during the course of the cross-examination of the witnesses, especially the professional witnesses, but then encompassed within the detailed written submissions that were filed on behalf of the mother. And what we say as a parent is that the judge had arrived at a decision because she was so concerned about the risk and the likelihood of risk, and so she failed to consider any of the mitigation that could have been put in place, and then failed to consider properly and weigh up, do the balancing exercise that she should have done in terms of whether it was right for these children to be removed, whether it was safe for them to be to remain with their mother, and ultimately what the impact on them was by doing that.
Right. Really, if we leave aside ground one, covers your grounds. Was it?
Yes.
If we were persuaded by them or any of them, what is the consequence?
My lord, I would say that the children are to be returned back to their mother at a safety plan as set out, and the Guardian has the most comprehensive safety plan in place as a recommendation, should be put in place.
Yes, well, at the moment, the way we have to approach things is that if the judge's decision stands, then it stands. If it doesn't stand, then we have to make a further decision as to what should happen next. And the available options are either that decision is reversed and we make some other final order, or that we make an order for effectively a rehearing on the basis that, if the appeal was allowed on the basis that the matters that you complain weren't dealt with need to be dealt with. And it might be thought that there's some difficulty in this court making an assessment that you say the judge didn't make.
I can see that. Of course, my client's wish would be for there not to be any further delay, but I can see that in terms of being able to assess whether those factors that I've referred to in some detail can mitigate the risks identified by her.
Well, that means that
Test.
another judge would have to
Yes.
look at this if that were necessary. But your position, as I understand it, is that the children should be returned while that process is continued.
Yes, with safety measures in place. The mother is more than willing to agree to more stringent protective measures, announced, unannounced visits, clear parameters in relation to supervision and contact with Mr. G.
Well, in a sense, you're simply opening a door. If that was the situation, it would be for others to go through it.
Yes.
And to suggest what needed, if anything, was needed beyond what existed before.
Yes.
In particular, as you say, there was an interim supervision order that would inevitably reactivate. Because one of the features of the judge's decision was that she didn't make a supervision order.
No, and didn't consider it, despite the request for clarification.
Right, is there anything else you'd like to?
No, my lord, I think my ground 4 I've already dealt with in terms of the failure to deal with the disputed matter. So unless there's anything else that I can assist your lordships with.
Ground 4 in a nutshell is that the judge needed to deal with the issue of whether there had been defaults or not.
Yes.
And then base her decision on whatever her finding was about that.
Yes.
And answering my lord's point a moment ago, it doesn't appear that she did make any legally valid finding in relation to that. The consequence would seem to be that she had to act on the basis that there had not been a default.
Yeah, I mean, just looking at that again, it just struck me that there is an implicit finding about their body language. It's not clear what it is, but
No, that's a
there's
difficulty.
something about their body language made it possible, and therefore that's a risk assessment,
Yes.
that there would be kissing and cuddling in future. Some
Yes.
contact which would be inappropriate and
The
pose a risk
difficulty is
to the children in some unspecified way.
we don't know where that assessment has come from.
No, but
given-
it's not. I mean, the fact is that your client made a decision to go on holiday together
yes.
with Mr. G and his family, and so it's not a very
Well,
big leap to kissing and cuddling. It's simply a question of whether the children were aware of any of this.
except that the evidence before the court was that there was no other occasions when the mother and Mr. G had
Yes, I
come into
understand that.
contact. So again, where the judges come to the conclusion that the body language, and I don't know what occasion she's referring to, would lead her to take the view that it was perfectly possible, it's difficult to understand, and I don't know where Her Honour has got that from.
Were they in court together at the same time?
With a screen in the middle, and so before Her Honour would come into court, arrangements were made for the father of the eldest child and the mother to be on one side, and Mr. G and the local authority on the other side. So I just don't know where that's come from. It's difficult to understand. I know that the local authority in their submissions make the point that in fact the first part of that sentence, in terms of Her Honour accepting that there may be confusion about what the elder child saw could fall either way. It's either a positive for the mother or a negative. But in fact, when we read the next sentence, I say that the judge has taken that as a negative but not made natural findings. She's not dealt with the evidence that was put before her in a detailed form in my written submissions.
Is there anything else, Richard? No. Thank you, Ms. Batchuk. Yes. Ms. Baker.
My lord, I just to clarify, I wasn't trial counsel, but I have trial counsel with me, so it may be that I may need to turn to
yes, I know,
Ms.
and
Stapleton for her assistance.
we've seen and read Ms. Stapleton's contributions at
Thank you.
various points. Yes.
Clearly, in terms of the local authority's documents, the local authority have filed 3 documents. Ms. Stapleton has prepared those. She was trial counsel. And that really sets out the local authority's position in relation to the overall picture. I think that just in terms of addressing some of the additional points made, I'd certainly read grounds 1 and 2 together.
Yes.
In terms of the adequacy of the judgment. And certainly, I think on behalf of the local authority, what we would say is that in terms of looking at the background, the assessments, identifying the risks, dealing with the evidence of the witnesses, we would submit that the judge has dealt with those in some detail in her judgment. And what appears to be a very important aspect for the judge and also for the guardian hearing the evidence was obviously the evidence of the mother and the evidence of Mr. G during the course of the proceedings. And that evidence, which obviously I didn't hear, it does seem to have very much informed the judge's view as to I would suggest, the ongoing emotional relationship between them. What they would want in terms of their relationship if it were not for the proceedings. I think that's very clear. And of course the fact that in September, I believe it was, the mother applied to take the children on holiday to Cyprus with Mr. G, which would have in effect been unsupervised by any third party, without perhaps really recognising the relevance and the risks involved in that. And that was clearly a concern, but particularly in light of hearing, I would suggest, the evidence in the case, which really did seem to be a turning point, because I think it's acknowledged by the judge and by all the professionals that it was a finely balanced case. And I think it's acknowledged as well, and the word is exemplary care by this mother of these children. And I think that is recognised by the judge, and it is recognised by professionals in the case. But it's appears to be the very high level of risk the judge took the view of, having heard clearly the evidence of the mother and Mr. G. I think the question then becomes whether the judge's analysis of the pros and cons and the safeguards and the effectiveness of those safeguards was adequate. I think I would have to accept that it could have been fuller. I think that has to be right, particularly in a case where it is finely balanced. But she does set out towards the end of her judgment that balancing exercise. And she does actually point to the fact that, and one of the points that I think was drawn to her attention as a point of clarification was that there was no, there was the separation of the siblings. And she does acknowledge there was no together and apart assessment. But in terms of clarification at the end of the judgment, having specifically set out at the end of her judgment that paragraph, I think it was 88, she says there's no together and apart assessment, which I think should have been completed. Nobody, in terms of clarification, then seems to have raised with the judge whether that was actually a gap and whether that should be further addressed. That just seems to be left as I read the judgment. And the judge clearly does make observations about the separation of the siblings. In terms of the ground 4 that my learned friend sets out, I think it's accepted by all of the parties that nobody was really clear where that evidence had come from. And the only thing that I would really say about that is, again, I would have expected perhaps that to be an immediate point of clarification when the judge raises a piece of evidence upon which she's included in her judgment, which all parties are unaware of where that evidence comes from, that would have been immediately drawn to the judge's attention for clarification to see whether that was something which actually inaccurately had gone into the judge's judgment, needed to be struck through, and whether it had impacted on her decision making in any way. And it doesn't seem to have been drawn to the judge's attention, and I would have thought that would have been the appropriate way to deal with that. But
is there an obligation to draw to the judge's attention reliance on a fact that hasn't been the subject of evidence or argument before? That's a point for appeal, isn't it? Rather than rewriting the judgment to exclude it.
It was such a striking...
You say it's an obvious factual error. I mean,
It's an obvious factual error that really should have just been clarified with the judge, I would have thought, and at least give her the opportunity to give the response to that. And it wasn't.
The trouble is then, if the judge says, well, I got that wrong, I take it back, then you're always left with wondering what impact it had, because it's the only example that she gives in that part of her judgment.
It is, but in that part of her judgment, she does go on to refer to other factors which she takes into consideration. And I think for the judge, one of the key factors was this incident that I think she draws on in relation to Mr. G being in a mood, and the response of the paternal grandmother and the mother to that, because it is suggested, of course, that the mother hasn't seen that side of Mr. G, and that's not something she's ever experienced, but her response to being told that he was in a mood, that the paternal grandmother's response, the suggesting that the father of the older child...
Wasn't the response to him being in a mood was to alert the father of the older child so that he didn't walk into a situation?
Of course, but of such concern that Mr. G's response was that could put the father of the older child at risk, so therefore he needed to get off with the older child at a different bus
Yes,
stop.
and the mother gave that warning.
Yes, but that...
I mean, I can quite see that illustrates it might feed into an estimate of what sort of risk comes from Mr. G, if he's the sort of person that you want to avoid when he's in a mood, and no doubting he is. But in a sense, if the mother herself has taken sensible steps to make sure that the father of the older child and the child herself is kept safe from that situation, I'm wondering why that, as it were, isn't very much a double-edged sword when considering all of the evidence.
Potentially, yes, that she's in effect taken a protective step, but it is an acknowledgement by the mother that there is another side to Mr. G, which throughout the proceedings, other than of course the judgment, which she is aware of, she says that that's not something that she has any awareness of, and he's never behaved in that way. But actually, that suggests that she has seen that side to him and feels the need to take those sorts of steps.
Yes.
Can I just go back? Sorry, just this point about I think we were talking about the comments in the judgment that the judge made about the mother sitting in the same room as Mr. G, mother and Mr. G outside court, and the body language comments. As I understand it, there was a draft of this judgment sent to the parties on a Sunday afternoon. with a request for clarification of some issues by the judge, and then the final version was delivered on the Monday, the day after. Were those comments in the draft that was sent to the parties on the Sunday?
Could I just turn and double check? About the mother being in the room. No, but nobody sought clarification. They were in the first version and no one sought clarification.
And probably follows that they were not matters of which the judge sought clarification when she sent the draft out and asked for clarification. And presumably everybody was then focused on.
She didn't ask for clarification. I think the request for clarification came the other way from parties, but not in fact from the mother.
In fact, just to be absolutely clear on this, the judge, when she sent the first written judgment on the Sunday, the 1st of December, had asked for any clarifications to be sent to her
But by that she meant requests for
from us.
clarification.
Yes,
Right, okay.
not herself.
Fine, okay, in which case I misunderstood, that's fine.
And I can also confirm that it was that point about outside of court and the body language was in the first version of the written judgment. I've just
Right. But the position, I mean, this is not an inquest into what should or shouldn't have happened, but speaking to you both, the situation where a party is on the wrong end of a judgment, their representatives have a judgment themselves to make as to whether to seek clarification or whether to appeal, or to do both. And in your case, I think you've told us that you felt that the judgment itself was structurally inadequate, and that it wasn't a case for you simply to engage in individual acts of clarification or correction.
No, my lord, I had started writing out what I thought I would be asking clarification, and then came to the decision very quickly that it would be a rewrite of the judgment and further submissions, and that, of course, is not what clarifications are for.
Thank you. Yes, thanks, Ms. Baker. And were you also, because we're here on the fringes of the appeal, I'm going to deal with the point about a finding as to whether there had or had not been a breach of the mother's protective undertaking.
But I think that the local authority would have to accept that a finding wasn't made. I don't think it can be said to be clear from the paragraph that my learned judge had identified. It almost cuts both ways. I don't think a clear finding was made. I looked very carefully at the written submissions, and it does appear the judge was invited to make a finding on that point, both by the local authority in relation to this kissing and cuddling in November, and by my learned friend for the mother. I have to accept that.
It would seem, I give you the opportunity to put another point of view, but the sense that would seem to be a foundational issue for the court when considering a radical order of the kind that was being supported by, in fairness to the judge, all the professionals. Whether the interim arrangements, which had gone on for a very long time, twice the length of the time the proceedings should have been continuing, had been effective or not. I mean, is there another way of looking at that?
Only in the sense that that clearly was the guardian's view when she filed her first initial analysis. And even in the event that there were no breach, I think the guardian's view and the judge's view changed, having heard the evidence. Because
Yes,
I think
that was about a different matter. That was about
Yes.
the mother's state of mind.
and potential risk going forwards,
Yes,
I think.
the risk arising from the mother's state of mind. And the judge found, and nobody's challenging it, that the mother was still emotionally attached to Mr. G. That's not been the focus of any challenge to that finding of fact. But we were talking here about objective matters,
Yes.
which is despite her mindset. The mother's case was, I have carried out my obligations under the order for the past year. And I was really, it seems, as you can probably tell, that I would consider that that was a basic fact that the court needed to decide or not if any doubt was being cast on that.
Yes, I think that in terms of the evidence, what I was more referring to was the fact that if there weren't proceedings, I think it was readily accepted that they would be together, and that they would have continued their relationship.
That is a different point, isn't it?
It is, but I think that's where, so even if there hadn't been a breach up until that point, with those emotions, with that perspective, and with that in effect admission, and then putting that into the perspective of the holiday and the very high level of risk.
But going back, and I appreciate, I mean, Ms Stapleton may have this more at her fingertips, but was it the local authorities' case that there had been breaches, or was there just, quote, concerns about this and that? I mean, was the local authority putting a case that the mother had defaulted on her promises?
I'll stand to be corrected by my learned
Yes.
friend Miss Stapleton.
No, that was not the case that was being put. In terms of the kissing and cuddling incident, the older child had indicated that the paternal grandmother was there in the park when that happened. So in terms of Mr. G only having supervised contact, there was no suggestion that that was not being kept to.
So that even if that happened,
It would not have been a breach of the undertaking.
thank you. My lord, so there was no suggestion by the local authority that the mother had breached the undertaking, because even if the older child was right in relation to the kissing and cuddling in the park, it was being said that the paternal grandmother was present, and actually she was the supervisor. So in terms of actually breaching the undertaking, that wouldn't have been a breach. So it wasn't being suggested by the local authority that that was a breach of the undertaking. That more goes to, again, the relationship.
Okay. Right.
In terms of the way forwards, if the court does allow the appeal,
I'm not inviting you to jump over anything here, but essentially the core of this appeal is in relation to ground 2, and the case that's being put against you. I appreciate you have no stake in this other than the protection of the children's interests, but the local authority now has no statutory order, and so the case is effectively that this was not an effective risk assessment, because by the time the judge effectively identified that there was a risk, and we can tell what sort of risk it was from reading about the other family, but as to how likely it was, in what circumstance it was going to materialise, whether it would actually get anywhere without being spotted, whether you having a supervision order and visiting all the time, if you wanted to, would be effective, all those things, it said they weren't there. And the second main plank to the appeal is that what we're left with is a bit of a dog's dinner, because there are no protective measures enforced under the orders which have been made. There's simply some recommendations as to what might or might not happen. That's the case against the current order, and others will have something to say about it, no doubt, but I just want to know whether the local authority has any riposte to that.
yes. So I think in terms of what I say about the in effect the pros and cons and the safeguarding and the effectiveness, is that the judge does deal with it. I think I would have to accept that she could have dealt with it in more detail. But in terms of, for example, considering the role of family members and the maternal grandfather, I know it's suggested that he would have done whatever is possible, but my understanding is that that is within the remits of him working, and him obviously having his own commitments. And I think there being a limitation on the tenancy of someone could stay there 3 nights a week. So that was the way in which my understanding was that the judge took that he would assist, but there were limitations
One of the
on what he
questions
could
that
do.
might arise is, let's suppose once the spotlight of the court was no longer upon her, the mother decided that she was going to go back on saying that she had ended her relationship and that really she hadn't ended it and that she was going to see as much of Mr. Goss as possible, including when the children were in her care. Is that going to escape the grandfather? Is that going to escape the older child's father? Is that going to escape your social worker?
Well, the social worker obviously doesn't have involvement so much.
No, the social worker would be under a supervision order because that's what
Yes.
everybody said should happen if the
Yes,
children were with their mother.
if there was a supervision order.
This is not a case where Mr. G is, it would appear, likely to cause significant harm to the children in one fell swoop. He is a cruel man who dominated his former partner and children in a quite horrible way. But the nature of the risk that comes from him is not in a sense, it's not a one-off event risk. It's a getting together with the mother risk.
And potentially, in effect, excuse the language, but perhaps a more slow and subtle creeping risk. Because I think in relation to the older children, from my understanding of the judgment, is that the relationship between the father and the mother of those children at the beginning was very good. It was very positive, as is described with this mother. And of course, this mother is describing not seeing that side of him at all, but it's a slow and subtle risk.
And even after everything that happened, that mother wasn't able to see him as he is. But the point I'm making is, where does the judge ask or answer the question of how is this risk going to eventuate, and what could be done to, as the cases say, either mean that the risk is less likely to arise, or that if it did arise, its impact would be less severe. And I think that's the whole that is being depicted. And your answer really is it's all in there in the judgment.
My answer is that it could be in more detail. I have to accept that. But she does consider the supervision order. She does consider the role of the maternal grandfather. She does consider whether those factors would mitigate the risk. And her conclusion was that she didn't think it could, that the risk was too great, was my understanding.
So does she actually identify how the risk would happen? I mean, she says he's just a very cruel and bad man. Does the judge actually identify some scenario in which the risk of harm would occur?
I don't think she spells out a scenario of risk for these children. What she does say is that her view is that he poses a very serious risk of harm to children, so all children, including these children. But I think I would have to accept that I don't see that it's spelt out that it would happen in this way.
Pointed in any sort of circumstance?
Only that the contact not supervised by a safe third party potentially will put those children at risk because he is such a serious risk to children.
Just any child that he comes into contact with in any circumstance.
Yeah, and that's
however fleetingly in the supermarket, however fleetingly in the street or otherwise. I mean, there's no grounding to the risk.
No, but I suppose without the supervision of a safe third person, which is why I put it in that way, and that's what the paternal grandmother was identified as during the proceedings, and the maternal grandfather is clearly identified as somebody who is safe to protect against those risks.
What is going to happen? Let's look forward under the judge's order to the next summer holiday.
Yes.
When it's suggested that the children, taking the older child in particular, would be for a total of about 4 weeks during the summer holiday in Town 1 with the mother, who is, I suppose she doesn't go away and is around and about Town 1. I mean, is she able to do the shopping with the children on her own? Is she able to take them to the water park or whatever it is on her own?
my discussions with my learned friend, Miss Stapleton, was the understanding was that the maternal grandfather would support contact, so he would be there to support that contact. And I accept it's not in an order, it's in a
No,
recital.
but leave aside what might have been in an order.
Mm.
But when you say to support contact, is it okay for him to say, right, so you're going to take them to the water park today, see you at 6 o'clock and make sure that Mr. G isn't there? Or does he have to get in the car and go to the water park on a day when he would otherwise let them go?
I would read that there has to be, that he'd be getting in the car going to the water park. He would be there, loosely, in effect, supervising. The risk is not the mother and these children, it's Mr. G. And that's what he would be,
Right,
in effect, protecting against.
Effectively, she has to have one-to-one presence from either the grandfather or by some other person approved by the local authority.
That's how I read the recital, that's the grandfather would take on.
A non-binding recommendation of the local authority that's been put into a court order, leaving the mother to make of it what she will.
Not even put into a court order, put into the recital of a
Yes.
court order. I think very much with the view that the maternal grandfather was clearly identified as a very protective factor, and that he would ensure that happened.
Yes, but what sort of a life is it for growing children to have to? I mean, we all understand that during the course of proceedings, everything can be very different and unrepresentative of life because every possibility has to be held in mind. But by this time, the court's made up its mind. So what sort of a life is it for these children if the interpretation is that they always have to be with their mother and one other adult for everything that they're going to be doing with her during the course of about half of their waking year?
Absolutely, but I'm sure,
What is
yeah.
the answer?
So the answer is that I'm sure, as with any development and progression, that this would be reviewed over time. If the maternal grandfather is entrusted, in effect, he's looking at what the risks are. One of the proposals, as I understand it, put forwards was for the mother to move in with the maternal
Yes, but
grandmother,
who's going to be reviewing that over time?
in effect, I suppose, but it has to be the maternal grandfather. He's the only person in that role.
And so if that's the case, why does one start from that position rather than saying, well, we'll keep with what's working for the children at the moment in the presence of the risks, which are going to exist even if they go to live somewhere else, but in a different way. We'll keep the children together, and we'll keep reviewing the situation while they're there. And if it doesn't go well, we'll change it.
I can only say that the judge clearly felt, having heard the mother's evidence, that those risks were too high, and that she wasn't able to take that particular path, which up until that point it sounded as though potentially people were open to.
Well, thank you very much indeed, Ms. Baker. I've wanted to press you just to see what the overall picture is, and it's been.
Did you want me to address you briefly on if you?
Yes. What should happen if an appeal was to be allowed on the basis of ground 2, effectively?
So we would certainly suggest that, not having heard the evidence, of course, which was relied on so heavily by the court, that would be a disadvantage, and I think it would have to be remitted for a rehearing. In terms of the children, I think that's a really difficult situation because, of course, the children have been moved, and the older child has moved school. And if the order were reversed and then reheard, there's the risk that they may move back and then move again. So I would say that potentially we would say the status quo at the moment should remain if it were remitted back for rehearing.
You say potentially. Is that on the basis of any other position other than that it's bad for children to go backwards and forwards?
It's been a significant step that's been taken, clearly the children have made those moves, and I think that that in itself will have been quite significant for these children.
Well, is there any argument really in relation to the younger child?
I think that there is less of an argument in relation to the younger child, of course, because of the awareness, the school, the proximity even, and potentially I'm sure the level of contact between the mother and the maternal grandfather will be such that the mother is seeing the younger child a fair amount in any event. It's very clear that there is a good and working relationship between the mother and the maternal grandfather. But again, in terms of disruption for the child, because that is in place in any event, I would suggest that a move and another move, particularly if the child is prepared for that, wouldn't be in the child's best interest.
This is the younger child.
The younger child.
Okay, right. With the younger child at school, is it?
It's school, but also awareness, and she will have been aware that she would have packed up her belongings and moved, so she will have some understanding.
I'm not sure I picked it up earlier, but what are the school arrangements? Where are the schools?
My understanding is the older child moved from school in Town 1 to school in Town 2, near to where her father, who she now lives with, is.
So it's not feasible. Yeah, okay, so there would have to be a move.
So there would have to be a move back to the initial school in Town 1.
Yeah.
I don't know if I can assist any further.
Anything else? No, thank you very much, Ms. Baker. Yes. It's great. It's good that you're here.
We'll see.
You raised with us whether you should attend, and it seemed to me, having read your document, that whatever arguments you want to put in relation to the appeal itself, we had to cover all bases, because clearly if the court was considering allowing the appeal, it would then have to consider the reversal of the arrangements,
Yes.
or not. And in relation to both of those matters, your client obviously has a very close interest.
Of course.
So over to you.
Yes. Well, my lord, when given the invitation to address a court, the temptation is always to take it. I looked at the skeleton arguments filed on behalf of both the local authority and the Guardian, and considered that they represented an adequate defence of the judge's judgment. I've listened with care to the debate and can see that there are material concerns about the adequacy of the judgment, and of course, to one degree, there's a certain satisfaction in the clarifications that I sought of that judgment. I know that when I've read Miss Batchu, relied upon them to some degree, in that they were, it seemed to me, obvious questions that required to be asked and answered by the judge, specifically that matter relating to action short of removal. The way in which I considered the right response for my client really comes to this, that the judge, having been pointed in that direction, appears not to have answered that matter. Doesn't appear to, well, did not provide any further clarification upon the balance and the balancing exercise that she was being re-invited to adopt. In those circumstances, I took the view that the judge, having considered that request, was in itself an answer to whether there was a need to clarify and amplify her judgment.
Well, can we just put our hand on what you asked by way of clarification? I'm remembering that it's in, I think it's paragraph 18
Yes.
of the skeleton argument of Ms. Batchu, and at the bottom of paragraph, page 22,
Yes.
the clarifications that you sought
Yes.
are helpfully set out, and points 1, 2, 3, 4. And in some cases, the process of clarification consists of a judge giving a judgment and then being asked some questions about it, and then a page or two follows in which the answers are given to the questions.
Yes.
But because in this case we've had iterations of the judgment, that's not what happened. And so, which is the question that you raised, that you were referring to a moment ago?
So it's the third question.
Yes.
Why action short of removal would be an inadequate outcome, given the pull of the sibling, and in particular the input of the maternal family offered by the maternal grandfather.
So in a sense, because it was your client's case was otherwise, that
Yes.
that these matters were not should not lead to a different decision. You wanted the judge to cover those bases,
I did.
and in regard to those matters, I think, as I've understood you, you're responsibly accepting that you didn't find the answer to that in the later version of the judgment.
No.
And similarly, under paragraph 1, was there a response to the query about there being a supervision order?
No.
Okay. Just a moment.
And my lord, as I read the judgment, the part of the reason why I reached the conclusion that I did was that the learned judge did in fact answer the question 4.
Yes.
One of the matters that my learned friend in her submissions, and indeed the manner in which the case was put, was that if there was an issue about durability of this separation, then there might be an argument for saying there ought to be an adjournment to test it out. And since that wasn't referred to in the original judgment, it struck me that that was a proper question.
And then it came up in the final judgment.
And there was an answer given
And
to
it's
it.
it's not a part of the appeal.
No. And so just to, as it were, to emphasise my thinking in this matter, given that the learned judge decided to answer or clarify question 4, her refusal or her declining to answer the first of the 3 questions that I asked for clarification in respect of, I took the view that that was essentially saying that's not a matter that requires clarification, that the learned judge considered that her judgment was an adequate answer to those matters and didn't require further clarification or amplification.
Right. And where do we go from there? Anything else that you'd like to deal with in terms of the substance of the appeal?
Lord, no.
You adopt what has already been said by Ms. Baker and what you confidently expect will be said by Ms. Hooter in a moment.
Quite so.
But can we then turn to the hypothetical situation in which the appeal succeeded and it was felt that the matter needed to be looked at again? There might be a quite substantial interim period when that would apply. Do you want to make submissions about what should happen during that interim period?
Well, Lord, in the event that one was required to look at the interim arrangements, I'd invite the court to say that the right outcome here would be to remit the matter without making any decisions about what interim arrangements ought to obtain. That will require very careful consideration of all matters that frankly have occurred since the judgment. And it would be too, with respect, simplistic to say, given the concerns about the judgment, what ought to happen is there should be a reversion to the status quo ante. I'd invite the court to say that the matter is, to some degree, more subtle than that. One does not know what the elder child's reaction has been to this dramatic change in her circumstances. One does not know the extent to which she has settled with her father and in her new arrangement. One does not know the quality and nature of the contact arrangements that have been put in place for her mother and her little brother. And one does not know how the family, both sides of the child's family, have reacted to and worked with each other to make this new arrangement work. And in those circumstances, I'd invite the court to say that it would be precipitate to assume that simply because the appeal is allowed, that one ought to revert to the position that obtained prior to the judgment. The best point, of course, is there's been a change in school. But it's the same point, really, that I've just made, that there's the school as well as all those other matters.
Well, you can obviously rely on the child having been in a different school for 2 or 3 weeks.
Yes.
That's just a fact. But I'm just wondering whether your too many unknowns point really takes you anywhere. I would suggest that the decision to refuse a stay and the fact that for one reason or another, which will be investigated, that was not picked up sooner, is puzzling in this case. Authority would seem to suggest, unless there was a good reason, this was a case in which a stay was fairly obviously appropriate in order to give time for this court to consider whether to grant permission to appeal. But I give you the chance to push back on that. But if that is the case, then isn't the burden really on you, or indeed the children's representative, to explain why matters shouldn't revert after what's effectively been a short period, and against a background where the child is very familiar with both households anyhow. But unless there are other matters that emerge, we're really left with the prospect of a change of school against a background of what was a very settled placement with mother and a very satisfactory home situation with your client. So it, as welfare decisions go, it isn't a big one. It's really what I'm saying, and that it's for you to sustain the position, however much your client might like to maintain the current arrangements, that the rehearing should take place on the same playing field as the hearing, unless for some good reason why not.
The submissions I've made in respect to that aren't going to improve by being repeated.
But it's the school.
It's the school.
How many weeks has the child been at the new school?
My lord, I assume, perhaps that's a dangerous thing to do, but one assumes that the start of the school year would have been the first week in January. So we'd be speaking in terms of between 2 and 3 weeks.
Before Christmas, not moved before Christmas.
I don't have any instructions on that. I'm afraid I just simply don't know the answers to that.
So it might be only, as you say, since the start of the new term 3 weeks ago.
Well, it might be, but what I recall that my client was very clear that the school that they'd identified for the elder child was one that was known to the family that she was going to be joining, and that there was no difficulty in her starting at that school. So I have no reason to believe.
Now, I was thinking more in terms of, for example, if the child had already begun to form friendships and settle in, and et cetera, as opposed to simply having been there for a very short, 10 days.
Yes. Lord, I don't have an answer to that question. It's a question I could have an answer to.
The move of the school is assuming significant importance, as it did in the exchange with my lord a few moments ago. It might be useful just to have some sense of what we're actually talking about.
Right. We'll be told on good authority, because it's only a phone call away by a number of you, what dates the older child has been at the school in time to.
Yes.
Since the judge's order was made. If there is a knockout answer, we'll hear it now, but otherwise we'll leave it for you to reply.
I don't have the answer to that, my lord, but I do have the answers to when the children moved from the mother and the answers in relation to the stay application. And I don't know if those will assist you now or later.
Well, shall we'll let Mr. Braithwaite finish, then I'll come back to you, and then the Guardian can make submissions. Was there anything else?
No, thank you.
Mark? No. No, good. Thank you, Mr. Braithwaite. Right, wait a moment, Miss Huda, if you would, just so we pick up whatever information we can.
Yes, so
'Cause you've been in electronic communication.
I have been with my instructing solicitor. So both of the children went to the maternal grandfather's home on the evening of the 29th, so after the oral judgment.
Both children to, hold on a second. On the evening of the 29th, so that was after the first application for a stay, the Friday evening.
Yes.
Yes.
And then the eldest child went to her father, Mr. Braithwaite's client, on the 3rd of December.
So that would have been what, after that weekend.
Yes.
Yes.
So the Monday. Our application for a stay was made on the 2nd of December,
How?
but the email, as I understand it, was sent to the wrong address and was resent on the 3rd of December. On the 5th of December,
Hold on, I'm just writing.
Sorry.
So you're saying effectively it was resent to the Civil Appeals Office, which is this court.
yes, on the 3rd. The Civil Appeals Office then called or emailed my instructing solicitor on the 5th of December to ask whether the stay was agreed or not. And then my instructing solicitor was then later phoned that day by somebody from the Civil Appeals Office, so on the 5th of December, to say that they had spoken to someone within the local authority who had said that a stay was not required because the children were already in their new placements.
And in the meantime, on the 4th of December, the appellant's notice had been
Yes.
formally lodged. And in effect, the issue of a stay then died a death as a result of those exchanges.
I think so. My understanding was that the stay was still going to be considered as part of our application.
Yes. But the process would then have been that the appellant's notice was the starting gun for gathering together enough information
Yes.
to be seen by a judge.
And we were then asked to provide our grounds of appeal on a fairly quick basis in order for that to be considered,
Right, and
along with the stay.
we can
So
the grounds of appeal have had two
Yes.
versions, haven't they?
Yes.
When were the grounds of appeal and skeleton
May
argument
I
provided?
just go to my emails and I can tell you the exact dates. So I was emailed on the 5th of December by my instructing solicitor, who said that the Civil Appeals Office had asked for the skeleton and the grounds for the following Monday. The 5th was Friday,
Yeah, the Monday was the 9th,
yes, which is when I
right, because that involves a shortening of the time, because the normal rules allow you much longer to file skeleton.
that's right, and we had understood that because the stay was being considered.
Right, so you were given until the 9th to provide skeleton argument grounds. Were they in fact filed?
Yes,
When were they filed as a matter of interest, or was that in the solicitor's
well,
knowledge?
that would be in the solicitor's knowledge. I know I emailed them to her extremely early in the morning of the 9th, so that they could be,
Right, so they would have been available to be filed on the 9th.
yes.
But is the missing page giving the grounds for the stay, which you said, even though in a sense there'd been an intervention, as I understand, by the local authority that said it wasn't required.
Yes, that I haven't got to the bottom of yet.
Because on the face of it, if you thought that they were going to be, a stay was still going to be considered, presumably
Yes.
that page is said to be attached to the,
I haven't got to the
Yes,
bottom of that
okay.
yet, but I,
would have taken into account, presumably, what had happened in the meantime, either children had been moved, or maybe not.
I I don't know the answer to that
It
yet.
doesn't look likely. I mean, the document was filed on the 2nd or the 4th. That's say the appellant's notice, and the exchanges with the Civil Appeals Office were on the 5th, you told us. So the document must have gone in before all of that happened
Yes.
as an attachment to.
Unless it was something that was sort of anticipated to be attached, and is often the case.
With my grounds and
So-
skeleton,
Somebody
Yes.
missed attaching.
it may be the position, but I will clarify.
Yes, I'm just trying to get clear in my mind when you might say the position had got far enough that there was something that was ready for referral to a judge, because the Civil Appeals Office can't refer things unless there's a core of information as to what the issue is and so forth. And then the question is, should the other parties be asked for their points of view and so forth? And after a move had taken place, this is a case in which it's very likely that if it had come to me, I would have said, well, before making a stay that involves a reversal of the arrangement, the father of the elder child should be consulted in simple fairness. But anyhow, it looks as if by a chapter of events, the boat had sailed
It clearly
by
had.
the time the matter came on for consideration of punishment. Okay.
But we'd even put our stay in because it was the 29th, the evening of the 29th, that the children were removed from the mother's care.
Right. Thank you very much.
Just in
yes.
relation to the school point, I don't have an actual date, but on the 11th of December, the social work did a visit, and at that stage, the older child had already moved to the new school, so it was prior to Christmas.
Right. So the 11th is the Wednesday.
And so there was a visit on that day, and she was already in a new school. I don't have the exact date of starting, but just in terms of it was before Christmas.
Right. And the school year. Well, in Hammersmith and Fulham it ends on the 20th of December. So it's probably not that different around the country. So in round terms, the older child looks to have spent something like 10 days or thereabouts at school before Christmas.
Potentially, yes.
I say 10 days, 10 calendar days, a couple of weeks of school. Thank you. Right. Yes, Consider.
Thank you, my lords. I, of course, endorse the submissions that have been made on behalf of the local authority and to some extent the father of the oldest child. I have provided in my submission quite a detailed response to the mother's
Yes.
skeleton argument. If I could just add a couple of points which perhaps haven't been addressed. Your lordships have asked the question as to whether the judge's assessment of risk and future risk and what the findings were in relation to that. Clearly, your lordships have referred to the finding that the judge found that the mother hadn't emotionally separated from Mr. G. But I would say that she went further than that. And I set that out in paragraph 24 of my skeleton argument, subparagraphs A to E.
Right, this is in addressing ground 2.
It
Thank
does.
you.
It's
So
addressing ground.
page 60.
Yes, page 60. If
Right.
one reads
So do you want us to look at paragraph 24?
Yes, so I'm referring to paragraph 24 and subparagraphs A to E.
Paragraph 24 and paragraph
Paragraph 24A.
A. Thank you.
To start. So I refer to paragraph 72 of the judgment.
Yes.
I'll read it out just to
But no need to read it out.
I'll identify the finding, I think, which I seek to rely on. I agreed with the guardian who wanted the children to stay with the mother, that there are very real risks of the...
All right, you don't, as I say, you don't need to read it out because we can see it. We can see it there, and it has names in it.
Yes. And then we have then the next paragraph, 74.
It's right, is it? The finding that you refer to in place reliance on paragraph 72 relates to a very different sort of factual scenario in which G had abused his partner and other children than those involved in this case.
Yes, so it relates to those findings, but it also relates to the mother not...
Does the judge, as it were, track across from the sort of scenario, the factual scenario in which the previous abuse took place, to how that might manifest itself in a very different factual scenario where G is not in the same household on a permanent basis, or on a regular basis or anything like that? Just saying G is a risk to children, this is a point I took earlier, just saying G is a risk to, in fact, his children, or just to children, doesn't really help you understand what the actual risk in the particular scenario with these two children.
I understand, but what I'm particularly relying on is the issue of finding that the mother lacks insight into those findings, into the findings in other proceedings, and the real risks that arise from that set of that factual matrix. Yes.
Right, you were looking at paragraph 74.
So paragraph 74 continues with in this theme.
So the judge made a finding that if she could, she would resume the relationship. Yes. So what that again?
That is the finding about
Yes.
the lack of insight. I would say there's an implied, within each of these paragraphs, there's an implied finding of lack of insight.
Well, clearly the mother sees a very different man to the man that the judge sees. We've got that. But the question is, what then? Let's suppose the judge is finding that the mother would resume her relationship with Mr. G if she could, couldn't possibly be challenged on the evidence, and it isn't challenged. But the next question then is, what if the mother continued her relationship or had never stopped it? What would happen then? And if that happened, despite the mother being under an obligation not to do so, if that happened, what would happen then? Didn't the judge have to go on and follow through on her assessment that the mother was not out of Mr. G's clutches?
Certainly, it would have assisted all parties, particularly the
Well,
mother.
I mean, the first question is to you as an advocate is,
Yes.
does she ask and answer those questions?
She does not explicitly ask and answer those questions. One reading her judgment, and particularly these paragraphs, she and her own reference to her previous judgment in other proceedings seems to infer that those risks should be clear to all, and she repeatedly refers to those risks. So it should have been clear to the mother.
But the fact that the mother is, the judge is by definition right about the nature of this man, and she's certainly right about the mother not seeing things the same way as she does. But I think the point you have to meet is it not then compulsory, not just a nice to have, for the judge to go on and say, well, where does that leave the children? Because either the mother is going to go on being loyal to her promises, in which case the risks may not eventuate, or she's going to break her promises, in which case one considers whether the children could be rescued before they'd come to any real harm. And I'm troubled by the absence, as you can tell,
Yes.
of the judge considering that line of thinking and explaining to us and explaining to the mother in particular why it doesn't work. There may very well be an answer. I'm not saying that there isn't, but at the moment it doesn't come from the judgment.
It doesn't. But there was evidence heard about the mother being informed about the risks through work with the social worker manager. That was an area that was she was cross-examined upon, and unfortunately she wasn't able to express to the court a greater insight. And I think that was the difficulty that the judge was faced with,
Right.
with the mother.
But I think we can crystallise this point, as I'm understanding it, is that the lack of insight is undoubted. It's the consequences of the lack of insight that the court has had to then go on and consider.
It's undoubtedly that much more could have been said about this, and the judge could have expressed in more with more clarity about that. But in my submission, it must have been evident to the mother.
It must be
Evident to the mother from these findings, which she refers to, court, and particularly where the judge repeatedly refers to the risks that or the findings she's made in previous proceedings, what the risks to her children would be. I appreciate that is lacking from the judge's.
no, but I mean, if one takes the most florid aspect of this case, and the one that, fortunately for children generally, is still fairly unusual. It's a case in which a teenage child, maybe more than one, I can't remember, was tasered
Yes,
in the home.
one child.
One child, but the other children knew about it, which is very, very extreme. So, I mean, is it suggested that, given any opportunity, the Mr. G is going to start behaving like that towards these children? And one would have thought that if he did, then there are a number of tripwires that would immediately bring that situation to a head. Because when he was doing it before, there was a conspiracy of silence. It took a long time for the teenage child to talk about it. But everybody knows now what he's like.
So we now have a situation where the mother, who knows about the history, knows the findings, could not, in her evidence, express her concerns about that as a potential risk. She knows the father differently, but as a potential risk, she could not express that to the court. And that's what the court was faced with. Consequently, we have this judgment which doesn't expressly convey what the consequences with this particular family would be, but does express that mother lacks insight into that.
All right. Is there anything more you want to say about Grand 2?
In terms of mitigation of the risk of
Yes.
harm, the Guardian did put forward a number of safeguarding proposals, very much in the context of the mother having made a decision quite soon before I think weeks before the final hearing, to separate. But having heard her evidence, and that had been explored in much more detail through cross-examination, she did move away from those recommendations. And she was quite clear in expressing that she didn't think that those safeguards would sufficiently protect the children if it remained in the mother's care. That's set out in her addendum report and is reflected in the judgment as well. I would say that the judge particularly refers to the maternal grandfather, because that was the unusual feature of the safety plan or safeguarding provisions. All the other provisions perhaps could be described as the usual ones: reviews, perhaps supervision orders, and monitoring of the family. But it was the grandfather's offer to spend some time in the family home, in mother's home, or to move in. That was the unusual feature, and that is particularly focused upon by the judge. And perhaps other matters haven't been specifically dealt with in a more complete way. But that feature was perhaps the one that the judge considered the most, being different from anything else perhaps that had been offered in other similar cases. So those are the 2 points I had intended to make in terms of additional submissions. I don't have the Guardian's instructions in respect of whether the status quo should remain if the mother's.
Sorry, say again. No instructions about
whether what the status quo should, whether the status quo should remain in respect of the children remaining with the father until the father of the oldest child until matter is reheard if the court allows appeal. I will have to take instructions on that, but I suspect she will support what the local authority and has said, and what the father of the oldest child has said to the court, and it's the concern would be likely to be about the disruption to the children, particularly the oldest child.
Well, I'm bound to say, while completely understanding what's said about that, I don't understand why they weren't those concerns weren't present in a far greater form on the 29th of November. I mean, was there an exchange with the judge about granting a stay?
I wasn't present at that hearing, but I understand that application was made, and subsequently you've heard the sequence, the chronology subsequent to that hearing. But I'm not aware of any other exchange between the parties and the judge on that issue.
No, but I mean, that was the disruption.
Yes, it was a disruption, but one has to bear in mind that we hadn't at that point seen the grounds of appeal. We weren't.
No, but having the children having been there for forever, what does it matter whether the mother had a decent opportunity to approach the Court of Appeal? Why did they have to be whipped out straight away? Apparently with the Guardian's acceptance,
there had been
or whether or not she supported it.
I don't know if she specifically supported that in light of the indication there would be an application for permission to appeal, but there had been a plan of how that transition would take place, and I think that's what was put into effect effectively, without any real thought about the permission to appeal, how that featured into the arrangements. I'm not entirely clear myself. I'm not able to assist the court in relation to that sequence of events.
All right.
I should assist your lordship further.
Is there anything else? Just excuse me a moment, please. Before we hear from what I'm suggesting is I want to put in writing about whether if the appeal is allowed, the arrangements first, they can send in something by 4 o'clock.
Takes up swimming to do anything except for about the status.
I agree, but I think we should give them the opportunity. It's not just whether it's referred to so long time. Ms. Batchy, sorry to keep you. Yes. Is there any reply?
My lord, there are just two matters that I do just need to deal with. One is that when you asked me earlier about the protective measures that were in place, my instructing solicitor reminded me that in fact the local authority application at the beginning of the proceedings was for an interim supervision order, not for a care order. So that was the position all the way through.
Right, so this was not, and it's worth remembering, it was an application for a supervision order,
Yes,
not an application for a care order.
yes.
Um,
The second point, and I think we might come slightly awry with page numbers now, because Ms Huda made the observation that the Guardian, that Her Honour had made reference to the Guardian's evidence that she didn't agree that any safeguarding matters could be put in place to alleviate the risks, having heard the mother's evidence. She refers to paragraph 72 in her submissions at page 60. My paragraph 72 of the final judgment is different.
Yeah, there are a couple of discrepancies
There
in the
are.
paragraph number, but the content is the same.
But when we look at paragraph 63 of Her Honour's judgment on page 84, there isn't any reference in there as to any of the safeguarding issues, and the judge herself doesn't then go on to consider the safeguarding matters herself, and I don't need to repeat those submissions. My lords, is there anything else that I can assist with?
No, thank you very much. Very well. Well, do take a seat. Can we thank you all and those who instructed and supported you for getting this appeal ready in a fairly short period of time. We will consider the matter and let you have our judgments as soon as we possibly can. I hope that will be in a matter of days, if possible, because we're aware that the case involves young children and it's very important to them and to their families. In practice, what will happen is that you will receive our draft judgments, which will make clear what our decision has been. Those are offered to you for a short period, probably a day or two at most, in order to identify and suggest corrections to any typos, obvious factual errors and so forth. It's not going to be the subject of a clarification process, but that helps us to make sure that the published judgment, which will be published online, will not have unnecessary flaws in it, and those judgments will be handed down electronically without the need to trouble you any further. Once you receive the draft judgment, please agree the consequential order and send it to us within the time indicated. If you have any disagreements about the order, and I don't predict that, but if you do, you just accompany the draft order with the parties' respective short submissions as to what is the right solution there. When the judgment comes to you, it will have a heading which will explain its confidentiality, so you can take instructions from your clients about it, but it's not to be further published until it's been published online in the normal way. Now, in the circumstances which we've reached, we obviously have to hold in mind the possibilities of either allowing or dismissing the appeal once we've had a chance to reflect. But we need to cover all the bases, and one of the bases is to understand what the consequences would be if the appeal were to be allowed. And it seems to us that there are two matters that we will, in that situation, require your particular help about, and it's only fair that you should be able to take instructions from those who are not present. The first is that in the event that the appeal is allowed and the matter is remitted for rehearing, whether the arrangements for the children should revert to what they were before the judge's order was put into effect. And the second subsidiary matter to that is, if that were to happen, what protective orders should be put in place, identifying which ones were already in place before the order of the judge, and whether any party suggests any alteration to that on an interim basis, because in that situation, realistically, it would mean that the proceedings would be continuing for a significant number of weeks until they could be reconvened. So is that request clear? I would suggest that you do so, that I will direct that you do so by 10 o'clock tomorrow morning. We are not looking for more than a page or two from each of you, and if in fact it's the possibility of there being one document which sets out everybody's position and you've been able to agree that, that would be even better. But we'd like to know the position of each party on those two matters. Is there any reason why that can't be provided by 10 o'clock tomorrow morning?
No.
No. Good. Is there anything else that any party would like to raise? Right. Thank you again.